McCulloch versus Maryland was a landmark case in the Supreme Court surrounding the topic of states' rights. In 1816, Congress passed an act recreating the Bank of the United States in order to help pay off the debts of the nation acquired during the War of 1812. The bank opened up a branch in Maryland, which the state greatly disliked due to its Democratic-Republican political identity at the time. In response to the new bank opening, in 1818, the state of Maryland passed an act that imposed a $15,000 annual tax on all out-of-state banks operating in Maryland. This act challenged the power of the national government. Whenever the bank received word of this new tax, James McCulloch, who was the clerk at the federal bank in Maryland, refused to pay the tax. As a result of this, the state of Maryland sued McCulloch in Baltimore County Court. In the original trial court, the court sided with Maryland on the issue. Next, the issue went to the Court of Appeals, which sided with Maryland also. After all of this, McCulloch petitioned for the official review in the U.S. Supreme Court. The issues raised by McCulloch versus Maryland were two things. One, does Congress have an implied constitutional power to create a bank? Two, if Congress does have that power, can states tax our federal bank? Chief Justice John Marshall was the one to make the final decision on the case. In response to the first issue, the court ruled that Congress does have the power to create a national bank. Marshall based his argument on the constitutionality of the bank from the necessary and proper clause of the Constitution. Marshall did acknowledge that the authority to charter a bank did not specifically appear in the Constitution, but according to the necessary and proper clause, Congress's powers go beyond those expressly enumerated by the Constitution. Maryland's interpretation of the necessary and proper clause was that Congress can create only those laws that are absolutely essential to carry out its express powers. Marshall interpreted the clause in a way that said Congress can do that which is useful or convenient for carrying out its express powers. Marshall said that the purpose of the bank was to raise and distribute money. To support the idea of the creation of the federal bank and its purpose, he also called upon Article 1, Section 8 of the Constitution. This states that Congress has the power to tax and spend money for the general welfare, borrow money, regulate interstate commerce, and raise and support armies. This evidence, combined with the necessary and proper clause, is what Marshall used to come to his conclusion that the Federal Bank of the United States was indeed constitutional. After the first issue was resolved, it was on to the second. Can the state of Maryland tax the federal bank? The state of Maryland believed that they had the right to tax the bank because it was an out-of-state bank operating inside of Maryland. Marshall responded to this issue with one of his most famous quotes: "The power to tax involves the power to destroy." He stated that the state of Maryland did not have the right to tax a federally created institution. He stated that it would be inappropriate for a federally created institution to be subject to the taxes of a single state. From this decision came the conclusion that federal laws are superior to state laws. In conclusion, Chief Justice John Marshall ruled that Congress does have the power to create a national bank, and that states could not tax a federal bank operating inside of their states. The original judgment of the trial court and the Court of Appeals was reversed. McCulloch had won the case and was not required to pay the $15,000 annual tax. This landmark decision in the Supreme Court addressed the heated issue of states' rights and put it at the center of attention. The judgment that federal laws were superior to state laws would continue to be a heated topic of debate and controversy all the way up to the Civil War that would occur around 50 years later. That's all we have for you today. Thanks for watching.